And now to our interview segment. My guest, Jonathan Akinsanya, is a dual qualified lawyer. He was called to the Bar of England and Wales in 1993 and was called to the Nigerian Bar in October last year. He's an expert in criminal law and procedure and has been involved in several high-profile corruption cases even before joining the Nigerian Bar. In this interview, we talk about some of the challenges confronting lawyers who seek to get called to the Nigerian Bar. Thank you for talking to us.
You're welcome.
I know you've practiced in London for over 20 years, but give us a bit of background. Why did you decide to come back home?
The first time I really started to think about coming home was when I was involved in a case actually called Damilola Taylor, which was a young Nigerian boy who was killed in a housing estate in part of London, Peckham. And that was the first real Nigerian case. I'd been involved in others, but these were the high-profile cases. It was a high-profile murder case. And so I was involved in that. I then was involved in a case which involved a young man who had married a white English girl, and he was accused of raping his wife.
A Nigerian man?
A Nigerian man, yeah. And I had to liaise with the family because they couldn't understand the concept that a man could rape his wife. And I had to make them understand that, well, in the English jurisdiction, that's possible. And so I had to deal with all the dynamics of it all. And I think because of my Nigerian background, I think they felt at ease with me. I then became involved in another case, which was an offshoot of the James Ibori case.
The former governor?
The former governor in Delta States. And I've been instructed to act for his special assistant, who had been arrested with a number of others in London on allegations of conspiracy to defraud Delta State, associated money laundering offences. And as a result of that, I had to come to Nigeria quite a number of times to have meetings with lawyers, etc. Because there were all sorts of, as you can imagine, Nigerian issues, Nigerian constitutional issues, etc., etc. And so, and there were ongoing proceedings here as well. And so I had to be involved by coming to Nigeria and having these meetings. And so, and then I was involved directly with James Ibori's case himself when he was extradited from Dubai, because of my knowledge, because I'd been on the case since the beginning of 2008, and so by the time he was extradited in 2010, I mean I'd had full knowledge of the case, and in fact Mrs. Poggerson, who was the special assistant, was acquitted of the charges. But so I became involved in that, and yet more opportunities to come to Nigeria for meetings. And so that set the tone really for me to start thinking that, you know, I just felt the time was right, that I wanted to be more involved with Nigeria. My friends who are lawyers, we used to talk about coming back. And so we were also involved with an organisation called the British Nigerian Law Forum that had been set up really to forge closer links between those of us in London in London and those who are in Nigeria, and so try and forge some sort of relationship. They had started to speak to the Council of Legal Education, the law school, trying to get waivers for those of us who are more than 10 years post-qualified, because we didn't really see the sense in us having to come back here and actually do the whole of the Nigerian law school. And so we were campaigning for a number of, well, quite a long time, I'd say years, to try and get the Nigerian Law School, Council of Legal Education to see the sense in not making us come back to actually do the whole of the law school. Because, you know, in London, I sit on the Bar Standards Board, which is the regulatory body for barristers. and I sit on the qualifications committee. And I'm aware that lawyers from the Commonwealth, certain countries of the Commonwealth, and Nigeria is one of them, who are 3 years post-qualified, do not have to come to London to do the whole of the English bar. They come and do what's called a bar transfer test, which effectively is a week. They do a number of exams, but over the course of a weekend. And they're given all the materials, so all they have to do is read them. Yeah, they don't have to do what they do at the English law school. So it's all encapsulated into a few exams over the course of a weekend. And then they have to do a period of pupillage, although the Bar Standards Board reduces the amount of pupillage that they'd have to do.
So you expected that coming back to Nigeria, you would get the same privilege and the same waivers, but tell us about your experience in the law school.
There were too many people who had to make the decision, too many different people. You know, you had the director, DG of the Nigerian Law School on the one hand, who was Tahir Maman at the time, who on the face of it was quite enthusiastic about assisting. Although some in my group would argue that, you know, yes, on the surface he was enthusiastic, but whether he was, well, you know, I took him at face value and I thought, well, he was enthusiastic. But, you know, you also had to consider the chairman of the Council of Legal Education, OCJ Okocha, SAN. You also had to consider the body of benchers, and the body of benchers, as you know, is made up of a whole number of people. And so to get all those people to agree, or, you know, it's almost impossible. So I think the reality is there were too many obstacles, and it was taking too long. And to be quite frank with you, I wasn't getting any younger. Those of us who wanted to come aren't getting any younger. And we sat down one day and we said, look, what do we do? And so, and what had really made up our minds was a couple of friends of ours had gone the previous year. And so we decided to put in the application and just go for it. I spoke to my wife, and my wife was very supportive.
Just so we're clear, what is expected of a lawyer from a foreign jurisdiction trying to come into the Nigerian law school?
You have to have a law degree. I mean, you just have to have a qualifying law degree, effectively. So you have to produce your degree and with your transcripts from the university that you went to, because I think the law school, they have to ensure that it is a qualifying law degree, that it's, you know, because I think the law school don't take, for example, part-time course. If you've been on a part-time course, they don't see that as being something that they want to accept. I mean, I don't understand the rationale for that. I think a law degree is a law degree, whether you did it in 2 years, 3 years, or 5 years. Does it really matter? At the end of the day, as long as you've got the core law subjects, because that's the test we use in London, and I think really the law school, if I'm being honest, is a bit backward in that respect. They ought to start looking at the fact that, well, people get their degrees in many ways. The other thing, of course, is that if I didn't do a law degree, in England, if I didn't do a law degree, I did say, let's say I did sociology. But then, after I finished my degree, I suddenly decided that, oh, actually, I want to be a lawyer. I can go and do a year's conversion, and convert, not with a law degree, but it would allow me to do all the core law subjects. And then that will make me eligible to go to either be a barrister or solicitor.
In London?
Yeah, but if I wanted to come to Nigeria, I couldn't do that. I'd have to do the law degree, which I think is, if you think of all the greats, some of the greats who have gone through and become lawyers. I mean, I'm talking about in England. I mean, Lord Denning was not. He didn't do a law degree. Yeah, he didn't do a law degree. He read maths. He was a mathematician. And there are my pupil master in London. He read physics. You know, other people I know, people do at Oxford or Cambridge, they do the classics. So, and then they go and do the conversion. But you see, I think that's where one of the areas that we fall down. Looking at the way things are here, I always think to myself, we're about probably 50 years behind London. But, at the end of the day, London was once the way we are. Do you understand me? But it's a question of, can we progress? And that's where the real challenge is. Can we move on?
So for us to make progress, what would you advise?
Personally speaking, having been through the law school, and let me say immediately that when I was first thinking about coming to the law school, I was really frightened as to what to expect in terms of the standard of teaching, and whether it was going to be of good quality. And to be quite frank with you, I was pleasantly surprised. I mean, there are some very able lecturers. I mean, I stayed throughout my time in Abuja. I felt it was safer for me there. One of the things that I was surprised about at the law school was the lack of training for advocacy. Because, to be a lawyer, going to court, you have to have advocacy training. I think it's key. I mean, in London, when you finish law school, and you can't go straight into practice. You have to do what's called a pupillage. So you go into chambers and you do a pupillage for 1 year. But also, you've had advocacy training during law school. When you start your pupillage, it's a compulsory part of pupillage that you do this advocacy course. So you have to go on a further course. And advocacy is key. And I just could not understand for the life of me why it was that at a law school, such as the Nigerian law school, they do not teach advocacy. I also was very concerned about the fact that, certainly, and I'm speaking for Abuja because that's where I was. I don't know how Lagos is or how any other places are, but I assume that they all move on the same, the same sort of way the course is taught. You'd have a lecture for an hour, and they would have given you work to prepare, and then you have breakout sessions. But the breakout sessions, you move in, so let's say there were about 1,800 of us at the Nigerian Law School in Abuja. So 700 would move to the dining hall. Maybe 800 would remain in the multi-purpose hall, and the rest would move to different places. But if you were somebody who was either in the multi-purpose hall or the dining hall, there's so many of you. You have probably, if you're lucky, you have 3 lecturers for 700 people. And then all they do is pass the microphone around. So they'll come to you and say, okay, you deal with that, you deal with this point. And so what you get is you get people hiding because they don't want to be given the microphone. So everybody's got their head down, hoping the microphone doesn't come to them. And really, if I have one criticism of the Nigerian Law School, that's it. In fact, in Bar 1, I didn't really get involved very much. But in Bar 2, my friend and I, his name is Abimbola Badijo, he's back in London now, but he and I decided that we wanted to play more of an active role in Bar 2. And so, from being in the House of Lords in Bar 1, we came to the front. And so any presentation, we would always put ourselves forward. But the thing is, it was all right for us to do that because we had the experience of public speaking. So we didn't feel shy about, getting up in public and talking, because that's what we've done for 20 years. You know, when I first finished I finished law school and I first became a barrister. I mean, my first day in court, it was awful. You know, I was hoping that my client wouldn't turn up. I was, you know, when she turned up, I was very upset, thinking, why did she turn up, you know? Now I have to go and speak. I just kept going on and on and on. I was talking for about 45 minutes. And I must have been repeating myself. Well, at some point, the magistrate said to me, Mr. Akinsanya, I think we've got the point, you know? So, you know, so for us at the Nigerian Law School, because we had the experience, we could put ourselves out there. But a lot of the youngsters had no experience of public speaking. Of course, they're going to shy away. And I don't think the right approach, actually, is to be threatening them with a microphone. And so that is the criticism I have of the Nigerian Law School, that I really think they need to look at, you know, what they're teaching and how they're teaching it. Because at the end of the day, all people do is they read to pass the exam. I mean, the difference between England and here, we have to appreciate there is difference, because it's a fused profession here, as opposed to in the UK, it's still a divided profession. So you either go to the bar, you go to the law society, you go to the law society, become a solicitor. So there are differences. But I think if you're training people to go to court, then you should have advocacy training. It's key.
The Nigerian Law School needs to take a second look at its entry process for lawyers, especially from other common law jurisdictions. There's also a need to tweak the calendar so that law students get more practical knowledge, especially in the area of advocacy. These are some of the suggestions made by my guest, Jonathan Akinsanya. What do you think, practical or not? Let's take the conversation online. You can send me a tweet, a mail, or a Facebook page. And in the months ahead, we'll be sure to get the authorities of the Nigerian Law School or the Council of Legal Education to respond to some of these suggestions. And it's on that note we end this episode of the program. Many thanks for watching. I'm Shola Shuyeli.